Today we're going to talk about the estate of Aretha Franklin. My name is Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is located in Minneapolis, Minnesota, and serves the Twin Cities and Greater Minnesota alike. If you like today's video, please feel free to hit that like and subscribe button. It really does help support the channel. Also, a couple caveats before we get going. First of all, this video is for educational purposes only. Second of all, we're going to be talking about Minnesota and other states' specific law. So if you live in a different jurisdiction, make sure to talk to an estate planning professional in that jurisdiction before you plan your estate. And third, when we look at the estate of anyone, be it a celebrity or not, the purpose is for educational only. We're not here to gawk. It is done with the utmost respect to the decedent and their family. Here today we're talking about the estate of Aretha Franklin, the Queen of Soul. I have a long history of loving Aretha Franklin's music. I actually was a professional competition and performance swing dancer for a number of years back in the day. So my heart goes out to the family that is dealing with her estate right now. That said, she was born March 25th, 1942, died August 16th, 2018. She died of pancreatic cancer at the age of 76, a very tough way to go. The estate at the time of her death was estimated to be $80 million. Now, initially, we didn't believe there was an estate plan. It was only later that we found that there was some planning done. In fact, we didn't just find a will or two wills, we found 4 different wills that may or may not be controlling. This led to multi-year litigation. So the question is, how did this turn out? What is the applicable law and what can we learn from the situation? Let's talk about the timeline of things. First of all, we thought that there was no estate plan done for Aretha Franklin. For an $80 million estate, that's a little bit scary. Now, when you don't do your own estate plan, you still have an estate plan. It's actually the estate plan of the statute. The statute is going to control who gets your things and how everything is divided and who the executor is. Now, initially, the distribution under the statute would have been to Aretha Franklin's 4 sons, and they all agreed that their cousin, Aretha Franklin's niece, would become the executor, Sabrina Owens. Now, 9 months after she died, several other documents were discovered. The first 2 documents were dated in 2010. They were found in a locked cabinet. The third document was dated 2014. It was scribbled in a spiral notebook that was found under some sofa cushions. Not how I generally advise people to plan their estate or store their estate plan, but such is the case. The 2010 wills basically had regular allowances for the 4 sons with specific gifts to each, and it had Sabrina and or Ted, one of her sons, as the executors. The 2014 will did something different. First of all, it gave the estate in equal shares to the 3 youngest sons. The reason for that was the 4th son, the oldest, named Clarence, he was an individual with special needs and was on government benefits. And if you watch any of my other videos, you'll know that if someone is on government benefits such as Medicaid, if you give them a large inheritance, what they have to do is do a spend down of that inheritance. And they can get kicked off benefits until they get to the impoverishment requirements of the various benefits. Basically, they don't benefit at all from the inheritance. It all just goes to the government. So she did actually what is pretty smart, and you disinherit the individual and give it to other individuals and have them take care of that individual. This generally does cause some problems because you can't control what the other sons are going to do with their money. They could just say, we don't want to deal with the 4th son, and they could take all their money themselves. You can't control from beyond the grave. What you can do is you can create a supplemental needs trust in your will, which she didn't do, and most people won't do with a handwritten will. Now, however, the 4th will was found a little bit later. In the summer of 2020, there was a probate hearing and litigation to happen that was going to determine the validity of the first 3 wills. At that time, the 4th will came to light. The primary document was an 8-page typed document entitled The Will of Aretha Franklin. Also accompanying the will was a 23-page trust, special needs trust or third-party special needs trust for Clarence. It was stamped draft and it was unsigned. However, it was initialed in places, and the reason it was unsigned is because she'd become so ill that she was unable to resolve several minor issues and unable to sign the document in the end. The document was drafted by the law firm Dickinson Wright. I don't know them. The devisees in the trust, in the will, were the trust for Clarence, the residue to be split among the 3 remaining sons, and then some specific gifts to individuals. So in the end, we've got 3 groups of interested parties. First of all, we have the 3 sons. Second of all, we have Clarence. And third of all, we have other recipients. There is a 4th group, of course, that we haven't talked about yet, which is the IRS. There's $7.8 million in back taxes plus penalties that were outstanding. So what are some of the issues that we're dealing with in this estate? First of all, holographic wills. A holographic will is a handwritten will. Generally, you just need to handwrite the key core provisions in the will, sign and date the bottom of it, and in some states, that controls. And in Michigan, where she died, or she was the resident, that's what you can do. You can handwrite the will, sign and date it, and you're good. Now, it is not required for a holographic will for there to be a notary or for there to be witnesses. Now, the first 3 wills, to my understanding, qualified as holographic wills. I don't know the results of the 2020 hearing, or if there were results of the 2020 hearing. It might have been kicked down the road as they came across more information, but presumably the first 3 qualified as holographic wills. The 4th will does not qualify as a holographic will because it was typewritten and she didn't sign it. One side note, Minnesota does not allow for holographic wills. You have to execute it properly. Now, during the pandemic, there was a law passed that said if you try to execute it properly and don't quite do it, we can still follow your intent and probate that will. And several months ago, that law, to my understanding, was made permanent. So we don't allow holographic wills, but you gotta try. The 4th will, not a holographic will because she didn't sign it or didn't date it and didn't handwrite it. However, she did initial parts of it. It did kind of have a date on it. And there is a Michigan law that said it allows a decedent's intent to be recognized even if the documents themselves are defective in execution. So that gives us 3 holographic wills and a defective will that may be her intent. So this leads us to probate litigation to untangle everything and find out what's going on. And there's a lot of issues going on. First of all, money. A lot of money is at stake. $80 million, less taxes. The estate is going to accrue revenue while it's being determined. We've got conflicting wills that don't agree with each other and we don't know which one controls. Of course, we're always looking for the intent of the testator. That's what you're trying to do in probate. Lastly, one issue that makes it a little more difficult is in none of the, at least the holographic wills, there is no revocation clause that says I revoke my prior wills and codicils, or at least I believe there isn't one. Presumably in the 4th will, there would be a revocation clause. It was drafted by a law firm. I presume they would have it. I don't know. I haven't read the document. Now, secondly, but we enter into probate litigation. And when you do that and there is an outstanding tax debt, that needs to be satisfied before any of the devisees can receive their gifts. So what the IRS did was it entered into an initial settlement with the estate. And under that initial settlement, there was an initial payment of $800,000 for taxes. 40% of the estate revenue was going to go to pay off state and federal taxes and estimated taxes that were also owed by the heirs. 15% of the revenues was going to go to estate administrative costs, and income beyond that would go to pay equally to the sons. For the youngest three sons, it would pay directly to them. For Clarence, the oldest son, who had special needs, presumably it's going to be put into a special needs trust by the court, but I don't know. Notably, in the initial settlement with the IRS, we did not determine where the principal was going to go. So that the little elephant in the room is the $80 million outstanding. We don't know how that's going to be devised. We kick that can down the road. The current status of the litigation, at least as of the time of this shooting, is that the family is still disputing the outstanding taxes, what exactly is owed. And you can imagine with an $80 million estate, it's a complicated issue. Now, the final resolution is still pending. When it comes out, I'm sure I'll give an update. Lessons we can learn from this estate. For me, the big one is privacy. We've got an $80 million estate. If you draft a will or don't have any estate plan at all, you go into probate and there are public hearings and all the wills become public information. Everyone knows how much there was, who gets what, and what other dirty secrets come out. For instance, we determined in one of the wills, I believe it was a 2014 will, that, or maybe it was in the 2010 will, that we did find out who Clarence's father actually was. If it was in a trust, that information would not be public. Now, very interestingly, and I don't know how to take this, in the fourth will, it was drafted by a law firm. Now, it's interesting to me that they decided to draft a will for that final document and not a revocable living trust. There could be reasons for this. Maybe there wasn't time to put the entire estate into the trust. That's a possibility. Maybe it was a stepping stone while they set up the trust. Maybe Ms. Franklin just sat down and said, I don't want to deal with the trust. I understand what a will is. That's what I want. I don't know. And I'm presuming that we're not going to ever find out because of attorney-client privilege, and the law firm is probably not going to be able to say anything. But it's an interesting thought. The second lesson is, of course, about holographic wills. In Minnesota law, holographic wills are not allowed, though we do have some exceptions for defective execution. Even if holographic wills are allowed, some people think, man, this is a cheap and easy way for me to do my estate. It's easy to mess them up. Notice in this case, we have holographic wills without rescission clauses, so we don't know which one controls. There was a supplemental needs trust that needed to be set up, or probably in Michigan, it's probably called a third-party special needs trust. It wasn't set up properly in the prior three wills. Amendments happened in these three early wills where things were just crossed out and changed. The problem when you do that is you don't know if the signature and date at the bottom of the document happened before or after the crossing out of various provisions and rewriting them in there. So you don't know if it actually controls. You may invalidate the entire document by doing that. So be very careful if your estate allows for holographic wills. Be very careful about executing one. Third issue and last issue is taxes. They don't go away even when we die, and they don't go away for heirs. The IRS will come in and find their pound of flesh. Lastly, I want to say our hearts go out to the family of Aretha Franklin. I have personally seen what this does to families, and it's not easy. Even when everyone agrees, once you get into probate litigation, it becomes difficult and all-consuming, and it is hard for everyone and can last many years. We all hope that you come to a favorable resolution to this and everyone walks away and the family stays intact. I hope that's what it is. That said, this is my take on the estate of Aretha Franklin. I hope you liked today's video. If you liked today's video, please feel free to smash that like and subscribe button. It really does help support the channel. If you have questions or comments on today's video, please leave them in the comments below. We're going to be doing, mixing in a few other videos on celebrity estates, not all at once, but they'll come in. We do a new video every other Wednesday, so you can look forward to that. That said, until next time, this is Gregory Singleton with Signature Law.